If you are a doctor or healthcare professional facing an interim suspension order in California, your career is in immediate jeopardy. Think of an ISO as an emergency or temporary shutdown. It allows a licensing board to pull the plug on your practice before a full hearing even begins. For a physician, an ISO is rarely a standalone event. It is almost always the precursor to a formal accusation by the Medical Board of California or the Osteopathic Medical Board. Navigating this requires more than just a general practitioner. You need a medical license defense attorney who understands the specific statutory hurdles of the California government and business and professions codes. To defend yourself, you first have to understand the two pillars of suspension under California law. The rules change depending on your specific license. The first pillar is Government Code Section 11-29. This applies specifically to the medical board and allied health professions. It is actually designed to be more protective of the licensee than general board statutes, using what we call the preliminary injunction test. Under this code, an administrative law judge must find two things. First, a reasonable probability that the board will actually win the underlying case. And second, that the potential injury to the public if you keep practicing outweighs the injury to you if you are shut down. In these cases, expert testimony is everything. Unlike other boards, the medical board allows for live testimony similar to a superior court proceeding. The second pillar is Business and Professions Code Section 494. This covers the Board of Registered Nursing, the Board of Pharmacy, and most other boards under the DCA. Here, the standard is a preponderance of the evidence. The board only needs to prove you violated the code or were convicted of a related crime and that your continued practice endangers public welfare. If you lose your license, you will lose your practice. Medi-Cal will suspend your right to bill. Insurance companies will strike you from their roster, and all of these penalties will continue even if you get your license restored. So, if you face an ISO, you need to fight hard and you need to win. Let's talk about your most powerful shield, the right to due process and fairness. Under the California and U.S. constitutions, your professional license is considered a vested property right. The state cannot simply take it away on a whim. This is why cases like Gray v. Superior Court are so critical. In that case, the medical board tried to use a backdoor method, criminal bail conditions, to suspend a doctor's license without notice. The Court of Appeal stepped in and made it clear, you are entitled to procedural due process. This means you must have reasonable notice, the right to see the evidence against you, and a meaningful opportunity to be heard before an impartial judge. However, the board can move with lightning speed. In cases involving imminent harm, such as allegations of sexual misconduct or gross negligence, an ISO can be granted within 5 days. You might only receive a 24-hour notice before an ex parte order is issued. If this happens, your right to fairness is preserved through strict statutory deadlines. For example, if the medical board obtains an order, they must file a formal accusation within 15 days, or the suspension is automatically dissolved. They cannot keep you in legal limbo indefinitely. When we get to the hearing, your defense strategy must be twofold, attacking the board's evidence and presenting a compelling case for mitigation. First, we challenge the evidence. Boards often rely on hearsay affidavits from investigators who weren't actually there. We fight to cross-examine these witnesses and introduce our own expert declarations to poke holes in their narrative. If the board cannot prove a reasonable probability of prevailing, the ISO fails. Second, we focus on mitigation and alternatives. Total suspension is a nuclear option that many judges are hesitant to use if a lesser restriction can protect the public. We may argue for a practice restriction instead of a suspension. This could include mandatory supervision by another physician, limitations on prescribing certain medications, or, in substance abuse cases, regular biological fluid testing. By offering the judge a middle ground that ensures public safety, we can often keep your doors open and your staff employed while we fight the long-term case. Another critical defense involves addressing out-of-state discipline. If California triggers an automatic suspension because of an action in another state, you have a 90-day window to prove that the out-of-state incident doesn't meet California's standards for suspension. The reality is that an ISO is often a starve-out tactic. By stripping your ability to earn an income, the board hopes to weaken your ability to hire experts and pay for a robust defense against the subsequent accusation. This is why moving quickly is non-negotiable. An interim suspension order is not a final judgment, but it is a professional emergency. The first 15 days are the most critical window you have to save your license, your reputation, and your livelihood. Do not wait until the doors are locked to take action. If you've been served, the time to fight for your right to due process is right now. For the best legal help, call the physician lawyers at the law office of Daniel Horowitz. Call for an initial consultation. The number is 925-283-1863. Again, the number is 925-283-1863.